Chief Whip.
Thank you very much, Mr. Chairman. Mr. Chairman, let me also take this opportunity to congratulate His Lordship Justice Tanko for their nomination. Mr. Chairman, Justice in his earlier answer to questions with regards to girls and their hijab in secondary school, he made some statement I want to clarify. Did I hear you say that for secondary school, you believe that their hijab should not probably stand, but if they are adults and working, for that, you agree that the work environment should allow them because they are adults and they should be able to decide how they dress. Did I hear you say that?
Yes, but this is the explanation. An adult does not have a dress code. A girl child has a dress code. If the particular institution has a dress code, and the dress code does not admit of hijab, except, of course, when you want to pray. That's why I made the exception, that if the girl child wants to pray, the girl child ought to be allowed to wear the hijab. But if, within the context of the school regulations, the girl child is not allowed to wear the hijab to attend classes or any official function of the school, in my opinion, it does not diminish from the quality of that girl child's religion. At the level of that girl child, in my opinion, it does not affect the quality of the religion.
Mr. Chairman, is it the belief of Justice Tanko that all working environment in this country do not have dress code? Are you saying that all working environments in this country do not have dress code?
You mean all working environments? No, there are some which have dress codes.
Exactly. So
others don't have dress codes.
So when you say for adults do not have dress code, it is children that have dress code. I'll tell you that children in my house do not have to wear any particular dress. But if they have to go to school, the school says you have to wear A, B, C, D. In much the same way, in some adults, when you go to the bank, some banks, if you go to some institutions, they'll be forced that this is our dress code here. So I want to find out from you whether the rights enshrined by the Constitution to all of us varies whether you are a child or you are an adult.
Mr. Chairman, at this stage, permit me to file a caveat. If you confirm my nomination, this question may come for determination. His Lordship the Chief Justice, knowing my religious bias as a Muslim, may empanel me. The honorable member is taking me into dangerous territory. This is a quasi-judicial proceeding, and he is inducing me to make a definitive statement on the situation. So I will plead with Mr. Chairman to allow me to establish this caveat. With respect to the girl child, I have said my position is that the girl child can use the hijab to pray. The school should allow them the opportunity to pray. The school may not necessarily allow the girl child to wear the hijab if it is not part of the dress code to the classroom or to the assembly. With adults, we are entering into dangerous territory. And I will plead with Mr. Chairman to allow my caveat to prevail.
Very well. You may move to other territories.
Mr. Chairman, I am happy the nominee had chosen to take this course so that, because in the earlier questions, he made a definite statement, and I was just trying to probe into what he definitely said. Mr. Chairman, I want to find out from the nominee when earlier he was asked about the COVID-19 and management of the rights of individuals, I mean, he said, yes, we must do everything to protect life, but when the matters come to court, the judges should do all to ensure that justice is served. I don't know whether you are aware that some few weeks, a pastor who was found to have congregated with some of his members had to be given, I'm not sure of the custodian terms, but I thought I had 18 months imprisonment. Just some few weeks again, others who decided to do installment of a king or a chief, the kingmakers were rather fined 48,000. As a justice of the appeals court, hopefully proceeding to the Supreme Court, do you think the two parties, the pastor and the kingmakers, in the eyes of the public, will say they've received justice?
Well, Mr. Chairman, we are not trained to pass comments on proceedings we have not seen and read, so as to appreciate the thinking pattern of the trial judge, the plea, the particular offense for which the person has been charged. But I assure the honorable member that I will endeavor to find out which court, where the proceedings were held, and between me and him, we can have a private discussion on the matter. It will assist him in this House in bringing it up to the plenary or to even the Constitutional and Legal Committee. But for now, the material he has given me is substantially speculative. I cannot pass any verdict on that. I'm sure he is talking about the disparity of the punishment. I have not seen the charge sheet. I have not seen the way the accused person pleaded. I have not seen the statement of offense, and so I cannot pass any judgment on that. But we will look for it and then we will discuss it.
Okay.
Yes.
Thank you, Chairman. I want to look at the judgment of the nominee. In the case of appeal number HI/46/2014, which was delivered on 29th of May 2014, you wrote at page 28 of your ruling that, and I quote, Chairman is saying page 28 is very serious. It's not the page that I'm talking about, not that page. I'm talking about his ruling. On that page, you said, and I quote, "It is the exclusive preserve of the legislature to legislate. Judicial creativity and activism must not include amendment of statutes by an expansive interpretation under the guise of a ruling or a judgment." Do you agree with the idea that the courts, in fact, do legislate sometimes under the guise of interpretation or applying the law?
Yes. As a matter of fact, in jurisprudence, what the courts do is to give meaning to the provisions of statutes. And sometimes the statute will not establish all that it intends. So it is referred to as the courts filling in the greases. However, in the context of this particular dispute, what has happened is that Section 18 of the Representation of the People's Law has provided for a definitive period within which a petition ought to be filed. And the petition is deemed incompetent until the order providing for security for costs is made and complied with. What the trial judge tried to do was to expand the frontiers of the law by giving the petitioner more time when 21 days has already lapsed. That is why we made that statement that what the trial judge was doing was to amend the statute, and that was not the intention of Parliament.
Now, there's generally been the belief that sometimes courts takes and depend and rely on technicalities instead of looking at the substance of the case. And I'll just give you two instances where this happened even at the Supreme Court. In the case Ablakwa and Arno versus Obichobi Lamte and the AG, the former Chief Justice, Justice Sophia, in her dissenting judgment, had this to say, and I quote, "I'm extremely concerned that of late, in the handling of matters involving the interpretation and or enforcement of our Constitution, there is a growing tendency for this court to become unnecessarily ensnared by the particulars and specificity of the facts of the suit and the technicalities of them in a manner which it has been pleaded. The big picture being constitutional interpretation and enforcement and its necessary legal impact on not only on the individual parties to the suit, but more importantly, also on the generality of the Ghanaian citizenry for the present and the future, it seemed to me sometimes tend to become of secondary matter," unquote. And on one of your own cases in the Dominion versus, I think, the NIB case, the former Justice of the Supreme Court, Justice Atuguba, had this to also say. I mean, it's so lengthy, Mr. Chairman. I'll just read just two paragraphs, just for want of time. Any certain, and I quote, "Any certain aside of proceedings is a judicial discretionary exercise and not permissible upon application after fresh steps taken. Quite clearly, no court has the jurisdiction to nullify proceedings, etc., for non-compliance with any of the rules under the High Court Civil Proceeding Rule 2004 CI 47. This rule has been construed in a manner I have done here by this court in several cases. The purposive rule of the construction of statutes so firmly entrenched in this court, led by Dr. Deteba, Justice of the Supreme Court, during his distinguished tenure in this court and statutorily reinforced by S10/4 of the Interpretation Act 2009, Act 792, heavily mitigate against the decision of the ordinary bench in this case." I already did this last one. "The purpose of an address of a person is to identify and trace him when necessary and can easily be cured by amendment where it is not endorsed on a writ without injustice to the other side. But for all this, the review jurisdiction of this court is not a federal appellate one and must not be treated aside." I mean, the last one just has to say that we must not heavily rely on technicalities at the expense of the substance. And he went ahead to say in this very ruling that he is hoping that in future the Supreme Court will depart from it. Now, looking at that particular case of the election and the petition and how you threw the appeal, in my view, were you not relying so much on technicality instead of looking at the substance of the matter?
Okay. Thank you very much, Mr. Chairman. I understand the question. Now, technicalities are of a kind. With all due respect to the learned justice of the Supreme Court, what he appears to have said in that judgment was that, in his view, he didn't think the absence of endorsement of the address, which is a matter within the rules, to have been rectified at the time of the proceedings or even at the time of judgment, should occasion the nullification of the entire proceedings. And he said that because earlier positions of the Supreme Court have been against the reliance on technicality to defeat the justice of every dispute. So his commentary in that judgment was a matter within the rules of court. My decision in the Havana case was a matter of violation of a statute, an act of parliament. That one is incurable. It is irredeemable. It renders the entire proceedings a nullity. The contravention of a rule of court is curable within the rules itself, and there's a provision for it. So there's a clear difference between the application of what will be termed technical by us in that appeal and the discussion his lordship was making in that review application.
Mr. Chairman, well understood. But in your case, with the 88 national security apparatus as security officers who were dismissed, in their pleading, they pleaded of natural justice not being served to them in the manner in which they were dismissed. And there again, you threw away their appeal, or they didn't succeed before you. But in that particular, did you believe, my Lord, that you explained the legal basis upon which that was thrown out in a clear way to answer for the natural justice?
Mr. Chairman, may I have the title of that case so that I can make a recollection? Do you have the title of the case?
Mr. Chairman, the title of the case is in the Supreme Court of... In the Supreme Court
no, the parties. Oh, the parties.
Oh, okay. Kenneth John Casey and 87 others as the plaintiff versus the National Security Coordinator and to the Attorney General.
That rings a bell.
And maybe if the appeals number was H1/77.
I don't remember. It will be difficult for me to remember those, but I remember the case. Mr. Chairman, just last week I noticed that this case is proceeding to the Supreme Court. There was an application for leave to file an appeal out of time. I recused because of my role in this matter. The application has been adjourned. Notwithstanding that, we can talk about the direction of the decision, but not about the potential success of the appeal. That would be prejudicial to what the Supreme Court would do. What happened in that case simply was this. Those national security personnel, several of them, and it is of concern, it is a matter that members of parliament should look at. They were appointees of MPP1, but their appointments were not particularly regularized. Then NDC2 came into power, January 2009, and they were all dismissed. Now, they were paid, I think, 3 months' salary in lieu of notices and absence of regularization, and they felt aggrieved, and they sued the Attorney General and the national security apparatus in the High Court. They lost. The simple issue we determined in that appeal was whether or not their claim that as national security officers, they ought to be entitled to the conditions of service of members of the Ghana Police Force was right or wrong. Now, in that appeal, with all due respect, I wrote a decision of the panel. Because you are now claiming rights under the conditions of service of members of the Ghana Police Force. We had to then take a journey into LI 1888. What are the conditions of service of members of the Ghana Police Force proceeding into retirement? And we found that from the evidence they adduced in court, none of them met that condition, so they lost. They have a right of appeal to the Supreme Court, and I wish them very well.
Mr. Chairman, what I wanted, I don't know if my Lord remembers, was whether his judgment you fully addressed the legal point. Because remember, they were talking about their natural justice. Or like they said in the, I managed to read a lot of your judgment, and in that they pleaded before you that just as they were being dismissed, they realized that others were being recruited. And for them, they were not treated fairly as Ghanaians, and natural justice was not done them.
That is administrative. That is administrative. And
Okay.
at common law and under the Labour Act, they cannot compel themselves on the employer, just as the employer cannot compel them to work. So that is not a matter for the courts.
Anyway, let me proceed. When should the Supreme Court depart from its settled precedent? What is your view about following decided cases where the Supreme Court decided to deviate or not did not uphold its own decision that they have taken earlier?
Well, Mr. Chairman, that provision is clearly stated in Article 1293. Article 1293 provides that whereas the Supreme Court is normally not bound by its own decisions, it can depart from its decisions. But its decisions on questions of law are binding on all other courts in the hierarchy. Now, judicial precedent is a cornerstone of the development of law, the common law. Precedent creates certainty. The bindingness creates a situation where lower courts will know what the position of the law is, and lawyers are able to advise their clients when the law is certain. But the law is not static. The law, like nature, develops. Society develops. So there could be a decision of the Supreme Court 5-10 years ago which will not be consistent with the times in which we are today. And so the Supreme Court has the power to change its position and depart from an original position. Many juries are in favor of a situation of departure. Many juries do not necessarily agree that every case before a judge must be adjudicated upon based on judicial precedent. Justice Biadade said it, that the practice where practitioners and judges always don't do original thinking. They always want to fit their cases into the straitjacket of judicial precedent should be avoided. So that is a constitutional provision. And as and when the Supreme Court is of the view that a position they have taken earlier is not consistent with current situation or will not serve the interests of justice, the Supreme Court has the power to depart.
Mr. Chairman, I want to find out from the nominee whether he thinks it will be fair for a lawyer or a litigant to a complaint about judgment that reads as follows, I quote, having considered the case of the parties and the submissions of counsel, the court holds that the case is unmeritorious and is accordingly dismissed, unquote. Such ruling doesn't indicate the principle of law upon which the case was decided, nor does it determine in any objective and clear manner how the application of that principle of law has resulted in the dismissal of the case. Will you consider this approach to judging a matter of serious concern that requires immediate attention by the bench?
Mr. Chairman, I understand the honorable member's question to mean not much reasons have been given for the verdict. It is a practice that, as appellate courts, we have discouraged because it doesn't help the losing party to appreciate on the face of the judgment why he has lost. And the judgment is actually intended for the losing party to know why you do not find favor with his position in the dispute. So it is not a matter we encourage. And of course, if any judge is in the practice of writing judgments like that, those judgments are likely to be attacked on appeal or at any other competent forum.
Mr. Chairman, from the CV, it looks like my lord has served very long at the commercial court. Am I right? I mean, you've been at the commercial court for some time.
Yes.
Am I right?
Yes.
I just want to find out how your experience at the commercial court has shaped your opinion about businesses generally in Ghana. As they appear before you, how do you see businesses in Ghana in terms of trustworthiness, in terms of adhering to agreement, in terms of complying with their obligations with their other partners? How will you generally describe businesses that come before you in Ghana?
Mr. Chairman, one situation that is very apparent is that our compatriots don't read. When they go to the financial institutions and take the money, they don't read the agreement. They are anxious to take the money. They sign anything. They are only surprised when the day of reckoning comes. So you find a party in court saying they did not really appreciate what they were signing on to. So that is one observation I have made. In recovery cases, most of the time they are interested in the money, but they do not read. There are also situations where third parties, they volunteer their title documents, affidavits are drafted for them, either by lawyers or the banks themselves. They commit their properties and take a small amount of money. The implication is that when the principal party defaults, the lending institution has something to fall on. At that stage, they say, we were not told. So it's all about education of our people.
Mr. Chairman, I'll take my last question on this. Mr. Chairman, I've asked this question of many nominees that came before us. And it has to do with the composition of the General Legal Council, especially that has to do with the disciplinary of lawyers. You have some Supreme Court judges there and appeals court judges there, knowing very well the decision of the General Legal Council can even be challenged in the High Court. And sometimes the appeal goes to the appeals court. I just want to find out from you, or I'm wondering if it isn't time for the composition of the General Legal Council to be relooked at to exclude serving Supreme Court and Court of Appeals judges. And the simple one that I'll give you recently is when a High Court judge made a ruling against the General Legal Council, and we have no other person but lawyer Okujeto virtually lambasting the High Court judge because thinking that these are your superiors that have gone to take a decision and you are turning that decision down. Don't you think that we need to relook at the composition of the General Legal Council?
Well, Mr. Chairman, I'm not aware of Mr. Okujeto's comments against the decision of any judge. But what I want to assure the honorable member is that in the exercise of judicial power, when the thing is wrong, it is wrong. You will find that in spite of the presence of senior judges on that panel, it took a lady high court judge to set aside their sanction. That must tell you that there is courage and there is integrity in the system. That is what I have to say. In other words, that judge, even though a high court judge, did not allow the superior presence of the senior justices on the panel to affect her judgment of the matter. She set it aside. That is courage. That is conviction. That is integrity. And I think we should commend that judge for it. I'm not interested in whether or not what she did was right or wrong. But I think at that level of the trial, she demonstrated courage. So my answer is that their presence will not necessarily affect the position a judge will take on the matter.
Chairman, thank you very much.
Minority Leader.
Chairman, let me thank you for your indulgence once again. The amiable tone and sternness of the nominee to many of the questions is warming. And Chairman, my first observation is when the Honorable Minister for the Honorable Atachia was on, even though you had earlier stated